On December 18th, Thomas Kwoyelo, a former rebel commander of the notorious Lord Resistance Army, appeared at the Gulu High Court Circuit in Gulu City. Kwoyelo had appeared before the International Crimes Division of the High Court 4-member panel of justices chaired by Justice Michael Elubu for a ruling on whether he had a case to answer. The former rebel commander was indicted by the court of 93 counts of war crimes and crimes against humanity he allegedly committed in Clark County in the present-day Amuru district. This was between 1992 and 2005. Following the closure of the prosecution case after concluding presentation of 53 prosecution witnesses, Kwoyelo's defense lawyers made a submission of no case to answer to the court. In their submission, the defense lawyers argued that in all instances there was insufficient evidence to establish a link between the accused and the allegations attributed to him. While the judges overruled the defense lawyers' submission, they found insufficient evidence submitted by the prosecution to pin Kwoyelo on all the charges. Justice Elubu, in a ruling, acquitted Kwoyelo of 15 out of the 93 war crimes charges.
Now, as regards counts 18 and 19, the victims were Cocaine Wilson and Ujo Martin, respectively. The evidence adduced by the prosecution shows that sometime in the month of February 1896, the two had been abducted from around Haiti at Chak Road, Karabanga Parish, in the presence of PW5, who was Egon's brother. They were never seen again. Apart from the evidence of PW5, no other evidence was called by the prosecution. The other three elements do not have any evidence to sustain them. Counts 7, 9, and 38 that Menya Odom, Omo Sano Omoyo, and Oriem Firino, respectively, were the victims who had been kidnapped with intent to murder. All the same victims were from Abera village, Karabanga Parish. The court has not found any iota of evidence to prove any of the elements of the offense in respect of these counts. The prosecution has not established a prima facie case in respect of these three counts.
Justice Elubu, however, ruled that Kwoyelo had a case to answer in the remaining 78 counts and asked him to put up a defense. The 78 crimes are related to war crimes and crimes against humanity committed in violation of Article 3 common to the Geneva Conventions, the Penal Code Act, and customary international law that includes enslavement, imprisonment, attempted murder, rape, torture, inhumane act, murder, outrages against personal dignity, violence to life and person, cruel treatment, and pillaging.
Counts 1, 15, 20, 50, and 74, the accused is charged with the offense of murder as a crime against humanity pursuant to customary international law. The essential elements of the offense are that 1, the perpetrator killed one or more persons; 2, was part of the widespread systematic attack directed against the civilian population; 3, the perpetrator knew and had knowledge or intended that it was part of the widespread attack against the civilian population. After applying the tests above to the evidence adduced in this part, the court finds that there is a case to answer in respect of counts 1, 15, 50, and 74. The essential elements of this offense are that 1, the perpetrator inflicted severe physical or mental pain or suffering of someone under the control of the perpetrator for any reason based on discrimination of any kind, that it was done not inherent or incidental to any lawful sanctions, and that it was part of the widespread systematic attack directed against the civilian population. The court finds that there is a prima facie case established in respect of the counts.
Kwoyelo's defense lawyer, Caleb Alaka, however, prayed for an adjournment so that they take their client through the 78 charges and guide him on what he doesn't remember and the testimonies of some of the state witnesses. Alaka says the defense intends to bring between 15 to 20 witnesses who will cover the aspects of their client's background, childhood, abduction, and issues surrounding his operation while in the LRA.
So the accused had requested us that we get the ruling, copy of the ruling, we get a copy of the charge sheet, we sit down with him, we go through those 78 charges, and we also, he remembers some of these things which took place in the court, and we also guide him on where he has not remembered. We guide him on what witnesses said, especially on those charges where court found he had been. Then we say, if we do that quickly, we can be in a position to get the best alternative, whether to keep quiet, or to give unsworn evidence, or to give sworn evidence. But he has emphasized he has witness. So in the circumstances, we are seeking for another judgment.
Kwoyelo is expected to return on January 19th next year for mention of his case before a defense hearing date is fixed by the court. Kwoyelo has been in custody at Luzira Maximum Prison since 2009 after being captured by the Ugandan Army in the Democratic Republic of Congo. He is the first among the top LRA commanders facing a domestic court on crimes he allegedly committed between 1992 and 2005 in Clark County in present-day Amuru District.